and share my screen with everybody. And we'll start from the start. Hopefully everybody can see that. Okay, so the first thing I want to do is, Jacqueline did a great job giving you a little bit of a background. Just one more thing, I've been doing real estate litigation for over 25 years now. So I have seen just about everything that you could imagine, the good, the bad, the ugly, and everything in between. And I know that if you've been in the real estate business, as long as I've been in the real estate business, you've seen the same. So what I'm really here primarily to do is to talk to you about some things that I am aware of that are becoming hot topics and hot areas of legal dispute, and potential ethics areas that are going to become hot areas. As part of my job with the Kentucky Realtors, as their legal counsel, I manage the Kentucky Legal Hotline, which means that when you email a request in for some legal assistance from the Kentucky Realtors, I'm the attorney that answers it. I answer about 200, maybe 250 different requests a year. It's a free service that's offered by the KYR. So if you ever have a legal issue, you might want to get some investigation on it before you go hire your own counsel or what have you, please feel free to utilize it. It's on the KYR website. One of the things that part of my job is to monitor changes in the code of ethics, because there are changes that occur every year. And I want to talk to you about one of them in particular that is going to be a big issue, I think, over the course of the next year. And I want to give you an example of one of these ideas or one of these thoughts in this. I want you to imagine that you see this on Ronnie the Realtor's Facebook. And he puts on there, "I'm tired of dealing with whiny single women and their annoying brats." And then puts the picture of the possum on there with all of her, presumably her children. And the question I would pose for you is, do you believe that this constitutes an ethical violation that you could be held responsible for? And feel free at any time during this discussion to give me your thoughts. I can tell you that about before November of last year, I think you would have been fine. You might have had a lot of people upset with you if you were Ronnie the Realtor, but I don't know that you would have had a problem. But I want you to look at the new Article 10. And this came out in November 13th. And it says that realtors must not use harassing speech, hate speech, epitaphs, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Okay. Now, what's important to remember is it's not a question of whether or not you are offended by the statements that are made. You can be offended by the statements that are made and it not be a violation. The question, though, is does that photo and statement in any way fall into this category? So let's go back and look. We're talking about harassing speech, hate speech, epitaphs, or slurs. So that's what it is. It's one of those four things that is based on race, color, religion, sex, handicap, familial status, national origin, or sexual orientation or gender identity. So let's go back up here. Is this hate speech? Well, my first thought would be probably not hate speech. We all have an idea of what hate speech is. I don't think he's saying he hates these people. He's just saying something else. Is it harassing speech? Is he going and directing this at a particular person? No, I don't think he hasn't tagged anybody in his Facebook. Now, if he had tagged somebody, that might be an issue, but he hasn't tagged anybody. And he says, "I'm tired of dealing with whiny single women and their annoying brats." But here's where it gets interesting. Is there an epitaph in there or a slur? And remember, that's essentially a way of describing a person by using something other than their name or their professional status or something like that. So is a brat a slur or an epitaph? He doesn't say annoying children. He says brat. And I think that's where the first problem that he's got comes in, because that is a statement about somebody. And does it relate to the familial status? Well, he's saying that basically family units that involve a single woman, he's going to call at least some members of that an epitaph. So again, it doesn't matter whether you're offended by what he says or if you think he's just, kind of out of date or what have you. The question becomes is, did he use an epitaph in the description of somebody's familial status? And I think you've got a strong argument that he does. And then again, does he talk about women, or does he talk about a certain type of woman's familial status? He's saying a single woman. So again, he's commenting on a certain type of person that involves their familial status, and he's using an epitaph, at least at one point, to do it. So I think he probably does have an Article 10 problem and a problem with Standard of Practice 10.5. Now the question becomes, why are realtors getting involved in these type of issues? And just so as a way of an explanation, not necessarily a defense or otherwise, the NAR has said that you don't get to take your realtor hat off when it comes to these kind of expressions. And what it means is that you can't say hateful, gender biased, or racist things in one part of your life in a public setting, step over and put your realtor hat on and say, well, I didn't say it while I had my realtor hat on. They're not drawing that distinction. They're saying if you're saying that stuff in general, you're putting the realtor name, the brand, our beliefs in jeopardy, and we don't want to be part of you. So it would make you subject to an ethics complaint, which could rise all the way up to the level of expulsion. Now, how many people here, before I gave that discussion just now, or before November, would have thought that this would have given rise to that kind of ethics issue? Anybody? Probably not. And so that's why I really want you to be aware of this. Now, you may say, is somebody really going to file an ethics complaint against me over this? Well, remember, anybody can file an ethics complaint. It doesn't have to be your client. It doesn't have to be your Facebook friend. It could just be anybody that sees this and files it with the KYR. And if you did this, regardless of whether or not they were damaged, and that's an important thing, it's not just single women that could bring this. Anybody that saw it, I could bring it if I saw it against you, and I could raise the complaint. And if the grievance committee said, yeah, it looks like there's enough here, and then it went to the ethics panel, you'd have a good chance of losing this, and even though nobody was injured. And the reason that it's open for everybody to make this kind of complaint is because it's a way to police the membership, to make sure that the membership's not doing things like this. Now, the other point about this is someone said, well, this is just a joke in poor taste, or whatever your thoughts may be on it. But if you look at it from this perspective, imagine that you were in a relatively small county. There were only 3 realtors, let's say, or 4 realtors. And one of the 4 realtors put this up on their Facebook, and the other 3 realtors liked it. If you were a single woman with 2 children, would you be comfortable going to work with those realtors? And that's the problem. The problem isn't just that you are saying something that might be offensive. It's that because you're saying that, you may not be denying people equal access to your services because they think you don't want them. And if people in a protected class think you don't want them or you won't work with them, you're violating our core mission, which is to provide to the public the right to own homes, to own property, and to do all those things. That's it. That's in the preamble of your ethics code. So it's important to note this isn't just oh, we're out to get people. We're trying to make sure that everyone in the public wants to use realtors and trusts in realtors. So be very careful. If your broker's on here, you need to talk to all your agents and say, wait a minute, before you post that joke, let's look at it. Be careful. And don't forget too, your competitors can complain. So if there's someone out there that just, for whatever reason has an issue with you and they see this, they can file a complaint against you. So don't open yourself up to potential issues. Now, any questions on that? Okay, so now we're going to go to the next thing. We're going to talk about advertising. Now, this is going to be a little more specific, but this is the #1 area in the last year that I have gotten questions on with regard to the hotline. And in particular, there's a battleground that's coming up with regard to some changes that were made to some regulations, and I'm going to talk to you about that as well. So first, imagine this Facebook post. I am the leader of Kentucky's best able-bodied real estate team, the Vaughn Realty team. In real estate, the only voices I answer to are mine, yours, and the Almighty's. I can help you sell or buy your home better than anyone in Kentucky. Want to look at it? I want to look at and make an offer on the $12 million property located at wealthy American Drive, Louisville, Kentucky. I'm your man. If you live in St. Matthews, you know that the most recent sale in your area was $1,645,000. That was my sale. And then a quote, Jason Vaughn is really something, John Doe, backup broker and buddy. So first of all, do people see some problems with this ad? Well, remember, first thing you do want to check on, and this is for brokers, because I want you to really look at this, because this is something that you're going to be held responsible to. First of all, at the get-go, before any check your box type regulations are out there, you need to make sure that your real estate advertising shall not be intentionally false, misleading, or deceptive. Do you feel deceived? If you came to my office and you thought you were getting what's on the left and you got what's on the right, would you want to file a complaint? That may be.
George Clooney doesn't even look like that anymore. He doesn't even look like that anymore.
So this is like the bad before and after. So, but yeah, this is one of those things. So, and take it away necessarily, because I know we've all seen some of those photos that people put up and you're like, wow, that's you. But let's take it beyond that though. One of the things you got to be careful of with photos is not just, obviously photo of yourself shouldn't be an impact, but what about photos of properties? Have you ever seen people put up pictures of property that's not the right property? Or is some amazing, whatever. And then when you get there, you're like, this isn't even what it looks. I mean, it's a totally different color. It's a different thing. So false and deceptive can go not just with what you're saying, but what you're showing. So that's the first step. Is it false and deceptive? You need to look at that right away. Then you got a question about, well, what is an advertisement? So, sorry, let me go back. All right, so advertising or advertisement means any manner, method, or activity by which a licensee of the commission, remember, this doesn't just apply to realtors, this also applies to real estate agents, make known or licensees make known a specific property for sale or lease or any services for which real estate license is required. Okay, so there are a lot of services in which a real estate license are required. It's not just the sale or lease. It can be property management. It can be some appraisal type services. There's a number of things, comparative market analysis. There's a number of things that at a minimum you need to have a real estate license for. And if it falls under that brokerage services, then it's going to be considered an advertisement. So if you're advertising a specific property for sale or lease, number one, you have to be a licensee to do that. If you're not a licensee, you're not allowed to do it. That's step one. That's only going to come up later. Or any services which a real estate license is required. So it could be any one of those things. It's not just if you're putting up the property, but if you're putting up something that says you can perform brokerage services, that's going to be an advertisement. And again, it's going to fall under this. Now, did the advertisement reference a specific property for sale or lease? Well, let's go back and look at that. It does, doesn't it? It talks about a property at Wealthy American Drive in Louisville, Kentucky. So we now know that under that test, I'm talking about a specific property. This would be considered an advertisement. Now, did it talk about any services for which a real estate license is required? Yeah, it said if you want to sell your property or buy your property, which a license is required, then that's going to be an advertisement. Now, I say all of this because a lot of brokers have very good advertisement requirement procedures for the old format of advertisements. Meaning, like when you were going to put up a billboard or you were going to do a yard sign or you were going to do an ad in the paper, they made you run it by them. But Facebook, Twitter, Instagram, all of these have changed the market. And to a large degree, I would highly doubt that most brokers are looking at every real estate brokerage service related post that their agents are putting up. And I think the KREC is now putting its arms back around a situation that maybe they didn't recognize right away as being a problem. But I am Facebook friends with 1,000 different realtors, and I can tell you there's some stuff I see all the time where I'm like, whoa, that is not what you should be doing. But as of right now, they haven't been too aggressive about monitoring it. But I think as competition increases and more people enter that internet market, you're going to see a lot more people saying, no, that's not fair. If I'll play on an equal playing field, but I'm not going to fight you if you're cheating. So I'm going to turn you in. And really, that's what we're talking about. We're talking about people taking an advantage over people that are following the rules. And so when you turn someone in, it's not because you're like a tattletale. It's because you're playing the game and saying, hey, look, I'll play the game and I'll compete with you, but you can't just pick up the basketball and travel down the court and knock everybody over on your way to scoring a point. That's not how we're supposed to be doing this. So the next thing you're going to look at is consent. Now, this is very important, and we just did an article, and Jacqueline may have gotten a copy of it. If she hasn't, it'll be coming out shortly, because there has been a change to this language, and it has caused a lot of confusion. And my understanding is that the initial point of confusion happened in Owensboro. So let me talk about that. This is the regulation that talks about what you need to have in order to advertise a property, what kind of consent you need. Now, if you are advertising real estate for the sale or lease, you need to have the written consent of the owner. All right, now that language in green has changed. A year ago, that said listing agreement. You need to have a listing agreement with the owner. Now it has been converted to written consent. I don't quite know why it changed. But we're in conversations with the KREC right now over this. I wish it hadn't changed because I think it's created a lot of confusion. But I want to let you know that it's not as broad a change as I think people have interpreted it. So, but let me go on first. First, you need to have a written consent. Now, what does that mean? That means that if you help banks on its short sale, and they call you and they say, hey, Jacqueline, you need to go put your sign on there because we're going to sign this listing agreement tomorrow, and we want you up and ready to go. So go put your sign on that property because we're getting this done. And you've worked for them 100 times before, and you go and you put your sign up on Tuesday, and on Wednesday you get your listing agreement, you are in violation. And you are in violation because you don't have written consent. So it doesn't matter if your agent, if the bank comes in and says, oh, no, we totally told her to do that. And we have this long-term relationship and this is crazy. And why are you guys doing this? You know what the KREC is going to say? I don't care. The rule is clear and you didn't follow it. That's a violation. And I know this because I've had this exact same case 7 or 8 years ago in front of the KREC where I defended a realtor under that exact same fact scenario. Exact same testimony, and the KREC said, oh, that explains a lot. Here's your penalty. So keep that in mind. Now, what has changed is what needs to be in the form of the written consent. So the written consent used to say listing agreement, and therefore you had to have all of that language that is required of a listing agreement, and that's in the regulations. Now you only need to satisfy the regulations. I'm not going to talk about what you need to satisfy the statute of frauds yet, but to satisfy the regulations, you just need written consent of the owner. Now, here's an important thing. Owner means all of the owners, not just one. So if you have Mrs. Smith and you don't have Mr. Smith, you have a problem. So you need to establish who all of the owners are, and you need to make sure you have that language in written consent. What else does that mean? That means that if you are working with someone that has the property in an LLC, their individual name doesn't count. You have to have it in the name of the LLC. And me personally, I would make sure they give me a corporate resolution that says that they voted on it and all of the members or the majority members necessary have approved it. Now, people say, but Jason, it says written consent, not listing agreement. So that means I can create an advertising agreement, and that advertising agreement doesn't have to, that relieves me of agency responsibilities. And this is where I think the disconnect came. My understanding is another instructor came in at one point and was talking to people and said, well, hey, here's the change, and that means you don't need to sign a listing agreement anymore. And technically, he's right. The problem is I think the audience heard that and said, oh, well, that means that I don't have an agency relationship with them anymore. So I don't have to get agency disclosures, and I don't have to do all of these things. And I can go to FSBOs and make a written agreement with them that says I'm going to advertise their property, but I'm not their agent. And if I bring anyone to them, they'll get me a percentage. And that will be the only time that I may have to get some sort of agency disclosure, but before then I don't, blah, blah, blah. And people came up with all of these theories as to why they're no longer agents under advertising agreements. And they all fail. 201 KAR 11121 section 7.2 is unequivocal. It says when a principal broker or a licensee acting on behalf of the principal brokers enters into a written agreement with a client, an agency relation is formed and the client is the principal. Boom, you're stuck. All of the same duties, all of the same responsibilities, everything you were supposed to do before, you have to do now. The only thing that has changed in any material way is that the form you use to get signed, the agency or the written consent form has to have less things than the listing agreement form. What's important to note too is that the listing agreement form doesn't even require you to list it on an MLS. It's just language that they use to describe a form that was needed. So the term listing agreement, as it's used in the regulatory language, doesn't even really reference a particular listing agreement. It's just language they put on there to describe what needed to be in the form. They've made a change, they've deregulated it a little bit, but your liabilities and duties are all the same. So brokers, keep in mind, if your agent comes to you with this fancy way of making a duck not a duck, it's still a duck. Okay, so you're still responsible for watching them, and you're still responsible to the people they sign agreements with as if they are principals and clients.
Jason, I have a question. I'm sorry. And again, this is all new to me, but like when you're talking about having written consent to promote or advertise a property. So let's say that Emily wants to sell her home on her own, and Shelly drives by or talks to her at church, and she's like, hey, I think I'm going to try to sell my house on my own, but if you want, you can, throw it up on Facebook. So she gives Shelly consent to do that. Well, then what happens if she's at the grocery store and it's been 2 weeks later and she sees Jason and says, hey, you can, like, what if we have two of our realtor members and they each, like if because the consumer a lot of times gets confused. we'll say, I don't think they do it purposely, but what happens if you have two agents who basically get consent from someone who's trying to sell their home on their own? Like, is there a time limit on these written consent agreements?
Well, there should be, because I think that's just best practices, but I don't know that there is a time limit prescribed by the regulation. What you're really talking about there is non-exclusive sale agreements or listing agreements. Or in the other way, they might say, well, I'll pay you an amount of money. Let's say a FSBO person says, I will pay you some money if you bring a buyer, but you're not going to be representing me. You're only going to be representing the buyer or what have you. And then you have like a non-exclusive buyers cooperating agency agreement, whatever you want to call them. There are a lot. I mean, you can have non-exclusive, for example, listing agreements. You can say, hey, you could sell it, or you could advertise it, or you could do it. That's perfectly acceptable. And, you know, you just want to be aware, you know, my thing is the NAR encourages exclusivity of representation because they think that's just the best way to do it. But it's not a requirement. You don't have to do it that way. As an owner, let's say, or even as an agent, you can consent to this. But that's why it walks through these next parts. Now, where you may have a problem is if you look at number 3 on here, if you are promoting or advertising a specific property listed by another broker, you're going to need that other broker to sign off too. So let's imagine that broker number 1 gets a listing, a non-exclusive listing agreement, and they put their sign up on the property. Broker number 2, and it's non-exclusive. It's non-exclusive from the beginning. And broker number 2 is hired to also sell the property. It would seem to me that the statute requires not only the consent of the property owner, but broker number 1 is going to have to consent to you putting on advertising related to this property too. So that's where it gets this little weird thing, but the statute or the regulations require that you're going to have to get those signatures. So the first thing is you're going to have to get written consent of the owner. Then if you want to put a sign on the property, you're going to have written consent. Then if there's already a listing broker, even a non-exclusive listing broker, you're going to have to get their consent too. So the only thing that changed in number 1 is the form that you need, what needs to be in the form. Number 2 was already in existence and number 3 was already in existence. So you've got 3 things that your form needs to knock out depending upon your situation and what you're going to do. If you're just going to advertise on Facebook, all you need is written consent. If you're going to advertise on Facebook and then put it on a property, on a private or listed property, then you're going to need number 2. And if that property's listed with another broker, then you're also going to need number 3. So it's a progression of how you are going to display your chart, your advertisement, and then also what needs to be in the form that you're having signed. Okay. All right. But if you have a set method of how you're getting your agency disclosure signed or what have you, you just need to keep following those as if you were doing just before. Now, there are also some talk about utilizing public information. If you recall, my ad talked about how I had been involved in one of those sales. You can do that, including information regarding real estate closed by another licensed to market his or her real estate brokerage to services. There's specific rules on that. And you can talk about your licensees, your participation in that sale, but you got to make sure if you're the buyer's agent that you say it's as the buyer's agent. Now, step 3, or let me go back for 1 second. Number 3 also deals in Facebook in this sense. What I have seen people do, for example, on Facebook, is to take a picture or take the listing information or a photo of somebody else's property, put it in their Facebook ad, and say something to the effect of, if you'd like to see this property, contact me, okay? And the argument that they're making is, well, wait a minute, I can represent that person as a buyer's agent, and I'm just telling them, come use me to hire me as a buyer's agent. Well, first of all, there may be some argument about deception because, you know, is the general public looking at this thinking that's your listing? And where I saw this once not too long ago was this really big Facebook post, and the guy had like 3 major giant properties. We're talking like $7 million properties. And he'd been in the business for like 6 months. And I was kind of amazed that he was listing properties that quickly. Well, it was because he was putting up other people's properties, giving the implication that they were his. Which maybe would elevate him in the mind of the general public. So in talking to his broker, I suggested, hey, you might want to pull back on that, or make it a little more clear. Say something, I can show you this property or any other property as a buyer's agent or something along those lines. The other component that I think he was in trouble is number 3. If you are promoting or advertising a specific property and it's listed by somebody else, you need to have your brokers need to have a reciprocity agreement, because if you don't, you've got another problem there. And you have a problem in that sense. And then you may have a problem under number 1 too, because you're advertising somebody else's property and they didn't give you permission. Most of y'all as brokers have reciprocity agreements a lot of times going with other brokers in your area, but be careful if you don't, this could be a problem. All right. This is a big issue, and it was fought about for months. Make sure you put the full name of the real estate brokerage that's registered with the commission, or the full name of the broker registered with the commission with a clear designation of principal broker status. People were using things like teams and what have you, and they kind of dwarfed, or there'd be a little thing off in the corner that would say the actual broker's name. The NAR is against that. They want to really emphasize the broker as a place for the general public to be able to go talk to, but that's not even dealing with ethics. This is state law, and state law says that you have to do that. So it must be clear and visible to a typical observer of the advertisement, the required language, and it can't be false, misleading, or deceptive. So when I say a typical observer, we heard a lot of discussion, for example, about Twitter. Well, Twitter only has 120 characters, okay? Then make your intro short, because you gotta make sure the broker's on there. Well, if you click on this page, it'll go to that page and then I disclose it. Nope, you gotta have your broker language in there no matter what. And if you could get around that by just doing a long intro, what do you think people would do? Well, they might just do a long intro to avoid that. So if the technology cannot work for the type of ad that you want to put up there, then you can't use that technology. This language is required. So you need to keep that in mind. And if the typical person is looking at this and they would not see the required information, then you shouldn't be using that technology. You know, for example, I saw somebody driving down the road one time in Chicago, and they had something on the back that indicated that they were a realtor and could sell your property. And they didn't say anything about a broker. It didn't say anything at all. It's just the ad, just that. And, you know, I said, well, wow, they're breaking the code of ethics through, you know, and it was a Florida license plate. And I said, they broke the code of ethics through about 7 states as they drove through it. But more importantly, if you can't get everything on the bumper sticker, then don't use the bumper sticker. You got to have the language that's supposed to be there. And if you don't, you don't. I heard one person come to me with a great idea. They put, you know, I won't give the away idea. I'll just say that the idea was really good. And I thought, well, that's really ingenious. It's illegal, but it's ingenious. And the bottom line was you can't do it. And they weren't happy with my answer, but they weren't in trouble either. Let's go a little further. An advertisement may include written text and affiliated licensee's first and last name or an alternate assumed name. There's some language that deals with that. And as long as the principal broker has informed the commission of the affiliated licensee's first and last name or the alternate assumed name being used. So if my name is, you know, Jason Vaughn, but everybody knows me as Buddy Vaughn, fine, I can put up Buddy Vaughn, but I have to file that with the commission so that they understand that this is my assumed name. And I can only have one nickname, okay? I don't know if there's anyone here remembers, old enough to remember the old Miller Lite thing, and you can call me Jack, or you can call me Joe, or you can call me Jim. It's kind of like that. You can't be 15 different people. You can only have one nickname. Can I use the term team if it's just me? Well, you know, that it's like, can I use the royal we when there's only me? No, you can't. The regulation clearly says that a use or alternate assumed name, you must have more than one licensee in your registered team. So you can't say team if you don't have a team. Now, why does that really make a big deal? Well, you guys put a lot of money into your advertising. So let's imagine that you have two people and you are the Vaughn team, or I'm the Vaughn team. And Mrs. Vaughn decides she doesn't like me anymore and divorces and quits the Vaughn team. Well, guess what I have to do? I have to find a replacement, or I got to change my name. I've got to get out of Vaughn team. So keep in mind that you need to have enough people in there so that you all, if you're doing that kind of advertising, that you're always safe if somebody leaves. Because if somebody leaves and you're down to one, you've got to quit using that advertising and that name. Can I use the term realty or real estate in my group name? No. The commission passed a resolution recently changing that. So if, for example, I was Vaughn Realty, I can't do that. Or I was Vaughn Real Estate, you can't do that. So you need to make sure that if you weren't aware of this change and you're utilizing that name, that you don't utilize that name anymore. All right, let's talk about your internet content. Now remember, why I'm going over a lot of this with you as brokers is to make sure you as brokers are doing this because you are responsible ultimately for the ads that are being placed. So every individual viewable page or post shall constitute a separate advertisement. Each advertisement shall contain the content required in Section 2, which we've already talked about. And you must be able to go through and see it without the observer scrolling down or trying to navigate to the page to get to where the proper disclosures are. So again, broker's name, all of that kind of stuff, that needs to be right in the beginning, right up front, and not strategically hidden. If the page or post cannot reasonably comply with Section 2 of the admin reg, the advertisement shall include a clickable direct link that is clear and visible. So if for some reason you can't do it, and there is, I would say stay away from this because there's always going to be an excuse of why you can't do it. There is an argument that you can do a direct link, and so you might be able to just show a picture and get you to the full thing. But what you can't do is have these multiple things or lots of scrolling to try to get you there. You need to have it right away. All right. Again, your code of ethics says that you need to be truthful in your communications and you need to present a true picture in your advertising. That's the final check that you have to do as a broker. So you've gone through the state regulations. Now you're doing that. Hold on, let me check one thing here. We've talked about the thing. Oh, one thing I want you to be aware of, because this has come up lately. Remember how we talked about Article 10? And Article 10 basically avoids discrimination. Be careful of the concept of mirroring, because that has been determined to be discrimination. And what do I mean by that? So let's imagine if I'm on Match.com and I want to meet somebody, and I say, I like walks on the beach, and I like pina coladas, and I like, you know, old Western movies, or whatever it may be. I'm not just saying that for no reason. What am I trying to do? I am trying to find someone that likes the same things I do, okay? So people will sometimes say to me, why can't I say I'm Kentucky's best Christian realtor? I'm not saying I won't work with other people, but you are in a sense, or you're showing a preference to a certain group, because what you're saying is I'm Christian and I like Christians. So it's not just that you're discriminating, it's that you're showing a preference, and you're doing it by mirroring. You're describing yourself in order to explain to others what you like or what you prefer. And that could be of any number of things. So, you know, you've got to be careful on that. If you say, I'm a family man and I believe in family values and I believe in marriage and I'm the realtor that supports that, you're saying what you like and what you don't like through a mirroring concept. By describing yourself, you are setting up a pattern of discrimination. So be very careful on that. And I can tell you that they've gotten a lot more adept at spotting that, and people have gotten a lot more adept at spotting that. And one of the ones that well, I won't get too far into that, but I'll just say be very careful, because it is an issue that you can do. By describing yourself in a certain way that falls under one of those protected groups, you may be mirroring, which opens yourself up to a complaint. Any questions? All right, let's go a little further. The last part is the broker review. So as a broker, you need to have written standards for review of approval of advertising. Now, why do I say that? How many of you brokers out there have that in writing? And how do you make sure that it is complied with? Because if your agent does not do that, if your licensee that you or your agent does not do that, are they at fault or are you at fault? So if you don't have a written advertisement standard of review and approval, whether it be by you or someone in your office, and that agent does something wrong, arguably you are as liable, or maybe even more liable, because of the nature of the broker agency relationship. We're talking about mentor-student. That's kind of the idea that is part of broker relationships. So if you are sitting there and you see this one agent just doing this stuff and you're not doing anything about it, and they get clipped, you're next on the list. And you may be even clipped harder, because you have a duty to have this in place too. So not only are you allowing your agent to do it, but you're not following your fundamental duty to have written standards of review and something that agent can know that they are supposed to follow and do. Whether it's a checklist, whatever it may be, you need to have it, because if you don't, just the absence of having it means a violation. So let's imagine this. Somebody complains about the agent gets called in and says, okay, I disagree with you. And the KREC says, okay, well, they may be right, but during the course of that investigation, we asked for the written standards of the broker, and the broker didn't have any. So now we're going to go after the broker for the mere absence of having that information. And you will, again, be held liable for acts by an affiliated licensee if you knew or should have known of it. All right. So let's talk about broker review. You need to review every advertisement or have a procedure. You need to have a defined procedure and approval process. You need to create your compliance checklist, meaning something that for each advertisement people can sign off on. You need to share this with the whole brokerage. There needs to be some method of enforcement, okay? And what I mean by that is there needs to be a way that you can tell people, take it down. If you do it a second time, this is what's going to happen. If you do it a third time, and then you actually need to enforce it. So you just can't have one that you open up and put in a drawer. You've got to go through all of these steps and have them all there and make sure everybody in your brokerage knows about it. And if you are an agent in a brokerage and you don't have this, you need to go to your broker and say, why not? Because I'm supposed to. All right. This last topic I'm going to talk about, because we're going to try to keep this at just an hour, I'm going to talk to you about photographing property, and we're going to talk about surveillance at property. And Jacqueline, I don't know, I know that some of the AEs have recently been sharing a form on these topics. And let me tell you, I've been teaching the code of ethics for years. I've been involved in a lot of different issues. Photographing property is going to be the next big problem. And why I say that is talking about my friends on Facebook, realtor friends on Facebook, and I've seen people post things. Oh, I never thought I'd see this when I was showing a house, and it would be handcuffs on a bedstand. Yeah, maybe sitting in the break room at your brokerage is kind of cute and funny to talk about, but would you want your bedroom on a photo on Facebook? And how hard would it really be to find out whose house that was? And what if the guy was a cop? It doesn't matter. This is somebody's home, and posting photos of somebody's home that you've been invited to, even if it's business purposes, is wholly inappropriate. Let me give you another example. Your person comes in and they say, hey, my husband's out of town, so I want to take photos of the house to share with my husband so he can help us decide whether or not we want to do this. Sounds perfectly reasonable. And the person walks around, takes all these pictures, and then and I hate to be very blunt here, but I will be, then that house gets robbed or a child gets kidnapped. And when they catch the person, they find all of the photos that they took surveilling the interior of the property, or the toys the children like to play with, or any number of things that you don't want out in the general public. What medications were in the closet, or what are in the medicine cabinet, or what have you. Any number of those things photographed and distributed could be a gross violation of privacy. It could be endangering the occupants of the home. And how well do you really know your clients? Meaning, if somebody tells you they have a husband working in Seattle, do you really know that? Or could they just be making a good lie for them to allow them to walk through and case a property that they're intending to steal or hurt occupants of? Or that's the girlfriend of the ex-husband, or whatever it may be. Photographing property without the permission of the seller in this day and age should not be happening. And why do I bring that up? So let's talk first. Sellers, listing agents, you should be talking to your sellers right away, and they should be saying something to the effect of, yes, I don't mind if people take pictures of the property, or no pictures of the property. You know, if they need pictures, they can get them off the MLS or what have you, or we will take a photo for them, but I don't want to show them where my security stuff is, or what's blocking my glass door, or any of that or where my gun safe is. No, none of that should be. Every seller should either give you consent or non-consent. And my personal advice is that you should be putting that in your MLS notes, meaning no photographs, or they have allowed for photographs. My guess is that probably within the next year or two, all the MLSs will have some kind of disclosure or requirement, and there'll be some kind of language to special instructions that'll need to be added to your listing agreement, because this is a hot topic. The one I know of for sure that came out a while ago, somebody came into a property, saw an emaciated dog in a fence in the backyard, took pictures of the dog, fed the dog hot dogs out of the seller's refrigerator, and then posted the pictures on Facebook and said, look at the owner, and told the owner, gave the address, and said, did to this dog, this is a horrible person, and I can't believe X brokerage would work with them. Well, it only took about 24 hours to find out the dog had been into the care of a veterinarian, had just come home, was on a specific diet to restore it to health, which did not include hot dogs. And what was most important is the person that posted this and patted themselves on the back for a hero never called animal services, never called the sheriff, never called the police, just publicly shamed somebody and was wrong about it. And what was really bad is the agent involved that was showing the property liked the post. So this person's reputation was ruined. Arguably, allegedly, they were completely innocent of any of these issues, and the brokerage was just doing its job. And does any of that apology by the party that did it or anything make a difference? No. Can you imagine the number of people that commented on dog abuse? Yeah. And now that brokerage is part of it, and that person is part of it, and it wasn't true. So the point being is the effects of disclosing photographs or things like that could be egregious and never repairable. So I think this needs to be something that everybody looks at and everybody has. And buyers, I think you need to tell, or when you're representing a buyer, you need to tell people in advance, no photographs unless we have permission of the seller. No streaming, because streaming is the same as photographs. It can be recorded. Don't do any of that. Now, the last bit in our last couple minutes. I want to talk to you about is surveillance. So real quick, the law in Kentucky. The law in Kentucky as it relates to video surveillance is if you go into somebody's house, they may surveil you anywhere on their property with video, with or without your consent or knowledge, except in one place. Does anyone know where that one place is? The bathroom. That's right. Can't put a surveillance camera up in the bathroom. So outside of that, you are completely open to being video surveilled. Now, next question. What about audio? So can they record audio of you talking on the property? The rule in Kentucky is that you cannot record somebody unless you are participating in the discussion. So let's imagine that Jacqueline and Emily and I are all standing in my kitchen, and Emily's asking me questions about the property, and I'm answering Emily, and Jacqueline's saying, well, wait a minute, I thought it was this, and we're all talking. Any one of us can record that conversation, share it with others, and it's no problem as long as it's one of the three of us. Now, though, imagine that the same conversation, except only Emily and I are talking, and Jacqueline's just standing there. Emily and I both know she's there, but she's not saying anything. And she's recording, and then she subsequently shares that. Then she has violated two laws. The first law is that she's recording and she's not participating in the conversation. The second is that she shared the recording with somebody else. So there are two violations there. Now, the next one is, well, wait a minute, what if they're not recording, but Emily and I are talking in the kitchen and Jacqueline owns the property, and Jacqueline runs next door and left her baby monitor on in the kitchen. And so she's hearing everything that I and Emily are talking about. That's called eavesdropping by electronic means, and that is also a crime. So listening if you're not participating, or recording if you're not participating, may be two different crimes, but they're both crimes. Now, the next question I always get from people is, what about a Ring device on a doorbell? That one's a little tougher because I don't know the rule. I don't know how Ring works necessarily. I think if you press the button and you start recording when the button is pressed, you might have a little bit more clearance. But if it's recording all of the time, regardless of whether the button is touched, you may have a little more trouble. I haven't seen any cases on it yet, but I can tell you what you definitely should not be doing is recording someone that doesn't know you're recording them and then sharing it, because that in and of itself is a whole separate crime. So the bottom line is, don't record people audio by audio unless you're talking to them at the same time. Now, the final little bit, it's all well and good. I give you all this law. Guess what? People are recording you. So when you're walking through a property, number one, don't talk about the property. Don't talk about what the seller was wearing when you walked in. Don't talk about the agent. Don't talk about how much you'd be willing to buy or why you would never buy this property. Assume you are being recorded, even if it's against the law, right? We look both ways to cross the street, even though one of those, there should be nothing coming. Hey, that's what you do. You practice to be safe. And from my bit of knowledge on this, I would say always assume you're being recorded. Always assume you're being videotaped, even if there is a crime. All right. I said I'd try to keep this to an hour. Did anyone have any last questions or anything? Jacqueline, you got anything?
You know, I was going to ask, what if someone sees something and it obviously violates one of these things? What is the procedure to either file a complaint? And I know most people know this, but a lot of times they want to tell us, and that we can't, you know, there's only so much that the association can do. So what is the proper protocol for one of our members who sees something that is clearly a violation?
Well, it depends upon which it's a violation of. So it's a violation of regulation or statute. Your primary remedy is to contact the KREC and file a complaint with them. There's a young lady there named Hannah that I think is handling those right now. So if you call up to the KREC and you say, can I please speak with Hannah, or can I get her email? I think that's even available on the website. You can get that. There's a complaint form that'll be sent to you, and they can help you get through that process. That's at the KREC, the KREA, whatever you want to call it. On the other side, if it's an ethics violation, that goes to the KYR. Every association, including yours, in the state of Kentucky, except Lexington, has turned over their ethics violation disputes to the Kentucky Realtors, the main state office. Lexington runs its own, and they have for as long as I've been the general counsel. I don't know what precipitated that or what did it, but the GLAR, for example, used to run their own, but they realized it was so much easier to have the state do it. And now, because a lot of those hearings are done by Zoom and stuff anyway, it becomes incredibly much more simple. Now, I would warn you of this, though. Be careful about throwing rocks. And why I say that is and so people, when they call you and they say, well, I want to file an ethics complaint, you're obviously not the source because you don't hear them. But so, I mean, you're not allowed to, when I say hear them, you hear them, but you're not allowed to set up a tribunal to decide it. But a lot of times people will do something that they think they're right on, and they haven't really done the research. So let me give you an example real quick. A person submitted an offer to a listing agent. The listing agent and the seller talked about it. The seller showed the offer to somebody else, and the other person increased their offer based upon seeing the first offer. And the person that had sent the first offer had stamped confidential on the top. And they said, oh, well, you violated the code of ethics. You disclosed this confidential document. Well, it turns out they were wrong. It's only confidential if you get it signed in advance of submission of the offer, a confidentiality agreement. Just submitting it with a stamp confidential doesn't mean anything because the seller hasn't agreed to do that. So you can't just throw confidential on something and think it's confidential. On top of that, the code of ethics says that it is the buyer's agent's responsibility, the cooperating agent's responsibility, to explain to the buyer offerer that this offer may not be held in confidence. And failure to do that is an ethics violation. So they threw the rock, the buyer's agent threw the rock, and guess what? The rock came back and hit them because they hadn't done what they were supposed to do. So you want to be very careful and make sure you do your research before you file a complaint. But the answer is not to come to Jacqueline. No offense, Jacqueline.
That's awesome.
The answer is to go to the KYR and file a complaint, or to go to the KREC if it's a regulatory statutory issue. So I'd love to hear what questions y'all got, if you got them out there.
Yeah, we have a group on here who's usually talkative.
Well, I get a lot of times I give these talks and people say, well, now I want to quit. I'm a little too scared. So I don't want to scare you out of the business, but if you have any questions, please feel free to ask them. Hopefully I haven't scared you out of this. You know, the main thing I would say that you should take away from today is really simple. Number one, be careful what you say on Facebook. The standards are getting much tighter, and the freedom to say things about protected classes is essentially gone. Number two, have a procedure for how you handle advertising. Have something in writing. Make sure that your broker's giving it to you, or if you as your broker have it, because that could become an issue later on. And brokers, that will be what you use to protect yourself from liability against a rogue agent. If you don't have that, you're going to go down just as bad as they go down, if not worse. And number three, think about photography and surveillance. Talk to your clients about it before you ever get to a property. Listing agents, I suggest you talk to them right in the beginning. You don't want to be on the other end of one of these controversies with your name splashed all over social media or in the press or anything like that. If you walked away with anything, just keep those three things in mind. And I appreciate y'all being on here, and hopefully I haven't scared you out, and hopefully we've helped you.